Thank you.
SJC-11434, Stephen M. Glovsky v. Roche Brothers Supermarkets, Inc.
Good morning.
Morning. Mr. Chief Justice and Associate Justices, may it please the Court, I'd like to reserve 5 minutes for my rebuttal. Experience. The one concept I am here today to make sure I say in person is dealing with experience. This practice of standing outside the doors of our local supermarkets gathering nomination signatures has gone on and been a right of candidates in Massachusetts for as long as anyone can remember. I've been doing it for 20 years, including at the Roche Brothers in Westwood, which has a long reputation for candidates gathering nomination signatures outside their doors. This concept of experience is the unique factor in this case because the history of these cases is one that was determined solely based on logical assumptions. When I came in this morning, I looked at the board outside of courtroom 2, and it has the history of Justice Oliver Wendell Holmes Jr. in this court. And it states his famous quote, "The life of the law has not been logic, it has been experience." And I'm here today to ask this court to take that experience, the experience of candidates across Massachusetts, into the primary count in making this decision.
Excuse me, Mr. Glovsky, did you allege this in your complaint?
Did I allege experience?
Did you allege the fact that you had used this particular supermarket as a place to gather signatures in the past?
I did not specifically allege that, and Your Honor, I'm not entirely sure why my personal, whether I allege that would influence the.
Well, how would we know then what the experience was supposed to have been?
Well,
There's a reference to it in your brief, I think.
I certainly reference in my brief that this activity is one that I appeared at the supermarket with the presumption of a right to get these nomination signatures based on my experience and the experience of candidates. That is all, in my opinion, assumed within the context of my basic presumption in arriving at that supermarket and announcing to the supermarket manager that I intended to be there.
But you haven't alleged that somehow you were singled out and not permitted to do this while others were. That's not what you're alleging here.
Absolutely not, and I see no need to allege that because the issue is really whether candidates in general have a right to go outside the doors of their local
So Roche
supermarkets.
Brothers presumably last year could have said, we're going to permit this, and this year said, because of a variety of reasons, maybe customers didn't like it so much, whatever, we're not going to do this.
Assuming that you're dealing with a right of permission and not a right on the Constitution.
You're arguing an absolute right.
It's an absolute right, not an absolute right that is unrestricted. The court in Pruneyard and in Batchelder both acknowledge the right of malls to adopt rules and regulations, to post a notice on the wall indicating that the market was not associated with or to go to court and prove economic harm. But the point of that is that those issues, those alternatives, were largely based on an ambivalence in the original U.S. Supreme Court case. Because the U.S. Supreme Court lacked experience with the activity, in the original case, a group of high school students went to a mall in California, set up a table, and almost immediately were asked to leave. The U.S. Supreme Court determined that the activity based on the size of the mall did not result in an economic taking, not obviously a physical taking, since clearly these people were at the mall, but did not result in an economic taking. But in the absence of experience, they could not know whether or not there was any economic damage going to be done to the mall from these people.
Mr. Glovsky, did you present any evidence before the trial court as to the size of the Roche brothers, the number of customers who came in? Was it apparent on the papers that this was a large commercial supermarket?
My brief did specifically address those issues in terms of size. I have no statistics in terms of numbers, but because this is a motion to dismiss, I was not given an opportunity to either create a record regarding these actual facts. And so we are basically, under the concept of a motion to dismiss, my understanding is that my brief should be interpreted to assume that the facts that would be relevant as far as this case are true. In fact, I'm kind of expecting and hoping your honors will do that to a large extent in order to reach a more substantive opinion in this case rather than simply reversing the motion to dismiss.
Well, if this were the Roche Fruit Market, a one-man show, would you be here?
Well, I would generally say no, although there may be some limitation on that. I think that in general, the concept of supermarket has included every aspect of daily function that used to be a part of our downtowns and is the one place that people routinely go to do for most of the activities of their life. My only hesitation in responding to your argument is, what about the communities in which the only place in that community to gather nomination signatures is in front of that, fruit stand? I'm not saying that this case necessarily requires you to consider that, but I certainly have thought about that in my, concerns over this case.
So would your position be that a person has a right to go to every commercial endeavor to seek signatures,
Well,
regardless of?
The Batchelder case looked at large shopping malls, and I consider the supermarket to be a sort of generic retail category. That is exactly how the Batchelder court looked at large shopping malls, as a retail category. And so I do not believe that every commercial establishment should necessarily be subject to this. In fact, if your honors wanted to consider that on a case-by-case basis, I would leave that to you. But the supermarket is the one routine place that everyone goes for, that basically the majority, that voters go. Supermarket shopping is a responsibility. Going to the mall is more of a matter of a whim. People who go to supermarkets, for the most part, are registered voters because they are household keepers and fulfilling a responsibility.
So what's the line? If it's a place, I go to the Walgreens all the time too, so does that, lots of people do, it's in my town, and so does that make it, because it's a place where people go, lots of people go, that...
Well, Your
all of a
Honor,
sudden-
I suggest that that's the problem with Batchelder to begin with. What is a large shopping mall?
Well, it's something that has many stores, that has common areas where people gather outside of their retail markets. It provides entertainment and attractions to get people to come to this area to shop in all of these stores. I've never heard a band play in Market Basket.
Well, I use the internet quite a bit today, and I think that that's an important concern in terms of experience. The societal change has taken people away from the large shopping mall. But while the large shopping mall has a number of those functions, I disagree with the concept that people gather there on a regular basis, and I disagree with the gathering. The concept of gathering was supposed to be a gathering that replaced the downtowns in the minds, in the logical assumption of the Batchelder court, and really, that type of gathering, to the extent it does occur at shopping malls, which I don't think is a substantial part of their activities, is not the kind of gathering that is similar to what my memory of a downtown was when I was growing up on the North Shore. My memory of the downtown was the place you went to the bank, the place you went to the baker, the butcher, the fish market, the fruit store. This was what the downtown was was, in my recollection, not filings, not downtown crossing in Boston, which is what the malls represent.
Isn't the difference, though, that in the downtown area, you've got public and private, and that's what the distinction really was in Batchelder, trying to recognize private property rights, but looking in the concept of private, what is being treated as public. And that's where the analogy is, not that you're going to always be listening to music, but that you have a right to certain things on non-private property that you don't on private property.
Well, I am not, whether you stand outside the Lord & Taylor store in the mall, or you stand outside of the doors of Roche Brothers in Westwood, you are still standing on private property, and you are still basically performing the same function and the same distraction from the customers and their activities.
That assumes that was the right that you had to stand outside, but I don't understand that to be Batchelder's holding.
May I interrupt? You reserve 5 minutes.
Yes.
So I'll interrupt you now.
Thank you, Your Honor.
Counsel, please step up.
May it please the court, my name is Mark Batten. I represent Roche Brothers in this case. What appellant and his amicus ask this court to do is to adopt a sweeping intrusion on property rights that would allow a candidate to use private property for the collection of signatures whenever a fact finder eventually would determine that it was a useful place for that person to collect signatures.
Well, it's not.
Up until right now, I take it that Roche Brothers has let people do this for years.
That's not in the record, Your Honor, so not something that could be considered as part of the appeal.
Well, I know, but when you're making these very historic arguments, it seems to me it may have some bearing on that.
Well, but it doesn't, Your Honor, and here's why. What Batchelder says is that there's a limited exception to the normal right of a property owner to exclude others. In the context of a shopping mall where there are areas that people are invited to gather for purposes that have nothing to do necessarily with the purpose of that business.
Do you think Batchelder intended to limit it always to just shopping malls? That there could be no freestanding store that would ever qualify?
The decision doesn't go that far, and we don't say that it does, Your Honor. But the problem is that if we're going to adopt the kind of balancing test that the appellant and his amicus suggest, then no one is going to know what the answer is until a jury decides it, because the kinds of factors that they urge this court to consider are, is this the best place in this community to collect signatures? Is it a useful place? Is it a natural choice, is one of the phrases that's used? Does it qualify as a modest retail establishment, which Pruneyard itself says shouldn't be considered? These are things that a store manager, for example, in Roche Brothers' position can't possibly evaluate.
I mean, it's not that hard if we were to simply say a large supermarket. You know you're a large supermarket.
Well, what is large, Your Honor? And
We could
Roche?
define it.
I'm sorry?
We could define it. We're pretty good at the English language. We can distinguish between a general store and a large supermarket.
Well, but that's
Is that the only problem? Is the problem of being able to know?
That is the problem of being able to know. And I submit that as eloquent as Your Honors are and as careful as you are in defining things, large is in the eye of the beholder, and you heard that in appellant's argument just now. In a small town where the one-man Roche fruit market may be the most convenient place to collect signatures, the position that the other side is taking would be, I have to be allowed to collect signatures there, even though it's not a large.
But sometimes you can't have precision in advance. There are important constitutional considerations on both sides here, and private property is only one of them.
But, Your Honor, in this particular case...
Ballot access is very important.
I don't deny that.
And it is entirely conceivable with changing social patterns that where ballot access is possible will change with time.
It's possible, Your Honor. But
And we won't really know very much by having something decided on a motion to dismiss about what kind of situation we're discussing.
But if we remand the case for the collection of facts, Your Honor, that is an acceptance of the idea that the right of a property owner to exclude someone can't be known in advance.
But Batchelder itself is a very I mean, it's facts are all through it. There is a record. The court refers to the specifics of that record throughout that opinion.
Well, actually, Your Honor, what I would say is when you look at the holding of Batchelder, as opposed to the factual recitation at the beginning of the opinion, which I agree is
Also
fairly
woven
detailed.
into the analysis as well.
The holding of the case is, we find that these areas, common areas, were dedicated to the public as a practical matter. That's what the holding is. And if you look at the cases, the uniform cases, I must say, there's not a single decision in any state, and certainly not federally, because there's no federal right at stake here. But we've cited more than half a dozen
But they
cases.
were all summary judgment cases, not motion to dismiss cases.
That's true, but
Because with a fully developed factual record so that you could see the various considerations at play, because there are not just private property rights at stake.
the
They
principle that
weren't ballot access cases, were they?
they were not. But the principle that comes out of those cases is that a single freestanding store doesn't have areas that are dedicated to the public as a
But
practical
that's not
matter.
always true. I mean, I can even think of LL Beans in Freeport, Maine. It's a freestanding store, and yet they have large areas for entertainment and all the things that are described in a mall in an adjunct to a freestanding store.
Well, but that hasn't been true across the broad range
All I'm
of
saying
cases.
is, you want to have some kind of, fixed, immutable principle, no freestanding stores.
Correct.
And I can think of an example that has nothing to do with Massachusetts, of course, but that meets a lot of the criteria that are spelled out in the cases.
Well, if the court were to go that direction and adopt a soft, subjective standard that we're going to have to turn to a jury each time, or respectfully, a summary judgment decision in which a superior court judge and ultimately an appellate judge is going to say, well, I put all this together and it seems to me that. If we're going to go that direction, then still in this case, there's no need to proceed any further because those facts were not alleged in the complaint. And the Iannochino case, the court is, I'm sure, familiar with, following on Bell Atlantic versus Twombly, requires a plaintiff pleading a case to plead sufficient facts to establish a plausible claim for relief.
Excuse me, just for clarity. Now, I read the plaintiff's brief. Was it part of the record that the Roche Brothers was on a 5-acre plot of land?
That fact is in the complaint.
And that it had a number of different departments, and was that also part of the
Yes, Your Honor,
record?
it is in the complaint.
And doesn't that tell us that this is a large supermarket?
It tells you the size of the supermarket,
Doesn't
Your
it say
Honor.
it's the only supermarket in the town of West?
I don't believe that's in the complaint, no.
And it has a bank.
There is a bank counter inside the supermarket, that's right. But on the factors that the appellant is telling you is relevant, that is, the function of this supermarket in this town, the available alternatives to collect signatures, none of that is in the complaint. And if those are, in fact, the basis on which a decision has to be made, then in order to allege a plausible claim for relief, the complaint has to include those facts. It's not enough to come in and say, well, this is a 5-acre store and there's a bank in there and I think they sell bakery goods as well as meat. They've got to come in and say, and here's what else is in Westwood or isn't. This is why this store is the place that we need to be. That's the essence of a plausible claim for relief.
But doesn't that contradict your earlier statement of certainty? I mean, isn't it cleaner to say it is a large supermarket than have to study the entire town and say it is the only place in this town where people congregate?
But Your Honor, if the question is what the standard's going to be. If the standard is going to be that any store that's over 2 acres in size is absolutely going to be required to permit signature collection, then yeah, that's very simple and straightforward. And if that's the rule, then no need to allege more than that. But that's not the position that even the appellant is taking in this case. What the appellant is saying is we need to evaluate each retail location on the basis of its function within the community. Amika says the same.
But I mean, there are two arguments here, and you're focusing on the issue of clarity, which frankly doesn't trouble me that much since I think we can provide clarity if we need to. I thought your other claim was essentially a question of the rights of property holders. But doesn't that come down to a question of what is the price of democracy?
No, it doesn't, Your Honor.
I mean, is it too much to ask for a large supermarket holder to let somebody stand in front to, not to be on a soapbox and give speeches, but simply to obtain signatures so they can get in the ballot?
It's a right that no state has ever held to be appropriate, Your Honor.
Has any state ever said it's not appropriate? I know
Yes.
of the cases you mentioned, I know are speech cases, not ballot access cases. And we're speaking about a specific right here, which is a right of democracy to be on a ballot, which is far narrower than the speech issue, is it not?
I take it the California cases, I mean, the Trader Joe's case involves soliciting signatures.
I believe it
does
did,
not?
actually, yes, Your Honor. But regardless, I'm not here to, I don't think it's fair to say that the Article 9 right somehow is more essential to democracy than an Article 16 free speech right, and that's somehow higher and so deserves to permit more intrusion on private property
No,
rights.
but the difference is that you actually need a real signature. You can't go on the internet and do a blog to get signatures. You need someone to physically sign that petition.
Yes, you do. But lines have to be drawn, Your Honor. No one would say, I get to stand in the middle of the CVS and collect signatures from people as they walk up and down the aisles. Even the appellant doesn't take that position.
No, it's time,
So-
place, and manner is a perfectly fine standard to be able to have at work. But I wanted to press a slightly different question, which has to do with, it seems to me that, the animating principle of Pruneyard and Batchelder has something to do with trying to replicate in modern life what had been happening in downtowns. And if you just talk about ballot access as opposed to the larger question, I understand that there's a public sidewalk, but certainly private storeholders have their locations in downtown areas right on the public, and it might be very inconvenient for shop holders to have people gathering ballot signatures right outside their door. But that's the way it goes.
Well, but it's not necessarily the way it goes.
But isn't that the way it went in the traditional downtown area? I mean, you have time, place, and manner restrictions, but it's still right outside this. I mean, that's what we're trying to replicate, the ability of people to meet other people for the purpose of gathering ballot
Right.
signatures.
Right, and the way Batchelder approaches that, and the way the other cases approach that, is that what makes a particular private piece of property equivalent to a miniature downtown is that that property has been dedicated to the public as a practical matter. That's the phrase that Batchelder uses, that the other cases use. Property doesn't lose its private character merely because people are invited to come and shop there.
Yes, but here, we're not talking about being inside the store, we're talking about being outside the store.
Understood, but that's still private property.
Right, it's just by virtue of the fact that the outdoor space, you're saying, is privately owned. And that's the problem.
And it
Serves as the entrance, I assume. Serves as the entrance to your facility.
In fact, what Mr. Glovsky alleges in his complaint that he told the store manager he wanted to do is stand outside the door and collect signatures. Where the line has to be drawn, Your Honor, is what makes it lose its private character and become part of a miniature downtown is that the owner of that property has elected to dedicate some portion of it to the public as a practical matter. There's no allegation that that happened here. There's no allegation that Roche Brothers
But
does
that's
that.
the owner's choice, that
Yes.
that the owner is going to be the one who decides whether or not to dedicate something to the public,
Yes,
as
Your Honor.
opposed to the public sort of choose it as a place where they meet, they sell Girl Scout cookies, this is just where you run into each other.
That's the way private property works, Your Honor, is that they have the private property owner has the right to exclude others. Now, in the large mall case, the court held those common areas had been dedicated to the public. That's the way they were used, and so they function the same way that a downtown does. But if a smaller store owner chooses not to do that, they have the right to do that. And that's the uniform holding of cases involving Target and Trader Joe's and grocery stores, and even grocery stores that are part of multiple store complexes. It's the uniform holding in at least 5 states, as we've cited in our brief. That's the way the balance is struck. And to strike the balance a different way, in particular in the subjective way that appellant and his amicus urge the court to do, prevents store owners from knowing what the rules are. And that's not just a matter of eloquent or careful opinion drafting, because the essence of the test that is requested is one that says what's best, what works. No one's going to know that in advance, and so what you're saying to private property owners is if you want to exclude signature collectors, then expect a jury trial. And property owners shouldn't be put through that. The law ought to be clearer, and that's the conclusion that every case to consider the issue comes to. Thank you.
Thank you, sir.
counsel.
Your Honors, let me again stress the word experience. This is a practice that has gone on in front of this Roche Brothers for as long as anyone can remember. When I asked the town clerk in Westwood 2 years ago, before I began collecting signatures, where were the best places to get nominating signatures of Westwood's voters, she told me everybody always goes to Roche Brothers, and she had no other suggestions. But given that this is...
Oh, I'm sorry, so the town clerk is going to decide? Which
Well, the
private
town
prop-
clerk is the person who certifies signatures. She is the chief election officer in the town. And so
She told you to go, this isn't in the record.
she didn't tell me to go. I asked her for a recommendation so I wanted to, as part of my campaign, to try to meet and get signatures from the citizens of all 29 towns that were part of this Governor's Council district. And she told me that everyone always goes to Roche Brothers. That's for local campaigns, for statewide campaigns, for federal, congressional, and senatorial campaigns. Everyone always goes to Roche Brothers. In fact, Roche Brothers, Westwood is really two roads. One basically goes in, one goes out.
But if she had said the hangout in town is the Cumberland Farms, I trust you wouldn't be saying the Cumberland Farms is going to serve this role.
Well, again, I reserve the question that for a matter of decision of whether or not is any other viable place. If everyone always goes, in most towns you can go to the dump. Westwood collects its own
But one
trash.
problem is you've not only brought this claim, a declaratory judgment, but you're seeking money damages pursuant to the interference with constitutional rights.
Well, my
The
understanding
problem with
is-
ambiguity is your brother has a point to the extent that if you're going to be saying, I'm going to be now faced with a money damage claim for a violation of constitutional right, I better be darn well sure whether I'm within the scope of places where I have to let the person give signatures.
Well, Your Honor, my understanding from the original Batchelor cases is that the civil rights statute applies, and to whatever extent money damages does or doesn't apply, I can't even speak to that as an issue. If someone is deprived of their civil right and the legislature believes that that should entitle to someone, and frankly in this case I don't expect money damages personally, or attorney's fees or anything else, this is a public interest.
But you brought the claim.
I brought the claim because I wanted to make sure that they were tied together still as they were in Batchelder for purposes of posterity, for purposes of precedent in going forward. For the next person when Your Honors find that the supermarkets are an appropriate and permissible right of candidates, I want the next person who is denied the opportunity to get signatures to still to be able to rely on this case as saying that they have a right under the civil rights statute.
Mr. Glovsky, what was the evidence that you offered to indicate that historically political candidates collected signatures at this Roche Brothers?
Your Honor, I did not, again, I did not have an opportunity to offer any evidence in this case. My complaint, I think, sufficiently alleges a constitutional right to have done so, which assumes, the factors, that the underlying factors. I feel comfortable in the content of of the complaint, that it was sufficient for purposes of a motion to dismiss it to allow me to create a record that would then be reviewable by the lower court and by yourselves in order to make that decision. I don't believe that my complaint was insufficient in providing sufficient details in which you could determine that. But beyond that, given the assumption that this is a long-established right, the fact that people have been doing this across Massachusetts forever.
Long-established
assumes
right,
it.
I don't know where this comes from. Does this come from Batchelder? That's where you're saying this long-established right
Well,
comes from?
this comes from matter of experience in society. Your Honor indicated that the California decisions prohibited the supermarkets, but those California decisions dealt with more referendum questions, not ballot access. Candidates have stood outside these supermarkets. Now, I suppose that goes back to an issue of common law, and the Justice Holmes quote that the life of the law has not been logic, it has been experience. Well, the experience in society has been that candidates, for as long as anyone can remember, have had the right to stand outside the supermarkets gathering nomination signatures.
All right, counsel, we'll have to leave it there. Thank you very much.
Thank you, Your Honors.